Namaskar and welcome to the talk show Insolvency Veterans. It is a unique talk show which has been planned in a way that we will be having every week a guest, a prominent guest who has either remained judge in Honorable Supreme Court of India or in a High Court or a member sitting or former of NCLT or NCLAT. Every week we'll be getting one such personality on our show who will be giving his ideas and his mind as to what was there in his mind or her mind during the period when he or she were passing any order with respect to NCLT or NCLAT. Today, I have the honor of introducing our esteemed guest, Dr. Deepti Mukesh. She has a remarkable educational background with degrees in life sciences and law. She has also done PhD on the topic of legislation for women in India, critical analysis vis-a-vis international conventions. She has represented India at an international conference on leadership for women in the US, where she was invited by the US State Department. She is also a Visharad in Indian classical dance, Bharatnatyam, which is a testament to her artistic talent and passion. You can well understand that how versatile the guest of today is. She is fluent in English, Gujarati, Hindi, and Marathi language. She has 30 years of experience as a lawyer at the Bombay High Court, where she has practiced in various courts of Mumbai suburbs, tribunal, and quasi judicial authorities. She has served as judicial member of National Company Law Tribunal from 2018 till 2023. We are honored to have her on our show today. But before we begin our discussions, I would like to explain the meaning of the name of this talk show, Insolvency Veterans. The name is a thoughtful play on the words and captures the essence of IBC. The word in has been written in red. That signifies the state of financial stress or insolvency that many companies face due to various reasons. The word solvency in black signifies the aim of the IBC to restore the financial health and viability of such companies through a time bound and transparent resolution process. The word veterans refers to the experts and practitioners who have been involved in the evolution and implementation of IBC and who have a wealth of knowledge and experience to share with us. Thus, the name Insolvency Veterans reflects the theme and purpose of this talk show, which is to educate and enlighten the viewers about the IBC and its impact on the Indian economy and society. She is a staunch nature conservationist and member of Worldwide Fund for Nature and Bombay Natural History Society for more than 3 decades. Please join me in welcoming our esteemed guest of the day, Dr. Deepti Mukesh. Welcome.
Namaskar. Firstly, I congratulate Mr. Rajesh Sharma to initiate and proceed on this program to give and impart knowledge about the insolvency, which is a very unpleasant word in society, and to remove the myth that insolvency is not negative, but it can be converted into a positive approach. I would also like to thank Mr. Sharma that he has chosen me to participate in this program and share my experiences with you all. Thank you very much.
It's our pleasure, ma'am, to have you here. In your opening remarks, please share that how do you think that this talk show will be beneficial for sitting NCLT and NCLT members, advocates, and insolvency and other professionals?
Initially, what I would like to say is that this talk show is not a completely legal show. So the common person or the person who do not have any idea about insolvency also can understand the basics and the process of insolvency under the code. Secondly, uh, the persons, those who will be coming and sharing in this talk show, will have some background and experience in dealing with the insolvency code. So our experience probably will be shared with the present participants and the members, those who are actively involved in implementation of the code, so that probably there can be more clarity, or what was the intent of we deciding certain judgments can be shared with the people in general.
Dr. Deepti, you see, you have a versatile personality. You are into music, you are into legal practice. You did your PhD also, and then you remained member of NCLT. Give us a brief account that what inspired you to become such a versatile person in different fields.
I won't say that something is inspired, but I would always like to mention that my parents were the source of inspiration. They always helped, supported, and inspired me for taking up any field, maybe number of fields at a time, or maybe single field in one particular time, and pursue it to the length, to whichever height I would like to go. So the support and the inspiration from my parents, and secondly the support from my family also, has helped me in coming out in a different field, having some knowledge about the field, or having some experience in different field.
Dr. Deepti, you see, you remained member of NCLT from 2018 to 2023 February, about 5 years or so. And during the process, you handled, if I'm not wrong, 7, 8 different benches of the country.
Yes.
You remained in Delhi, you remained in Allahabad, you remained in Jaipur, Kochi, so on and so forth. And you retired as a judicial member from Ahmedabad bench. Tell us, although the work may be of similar nature in all the benches, but which is the area which you liked most, station wise?
Benches wise, I don't think there is any discrimination I would like to do that I liked more, because once you are involved in the essence of work, whether it is from one part of nation or other, it doesn't matter. The only thing is that the different parts have different perceptions. So when you are dealing with a particular matter in particular region, the background of the people, or the financial condition, or the general awareness of the people also matters. Sometimes you have language barriers also. Like when I was handling the Kochi bench or Chennai bench, to understand the difficulties of the parties, when they come and appear before us, it was little difficult because we could not understand the language. So that time you feel that language sometimes brings some barriers. Of course, you have interpreters or the translators, but otherwise, Mera Bharat Mahan, so all entire India is good for us wherever they put us. And when I joined the services, it was very clear, whenever we join the services, it's very clear that you can be placed anywhere in India. So apart from Mumbai, I had seen many other benches. My experience with all the other benches was very good.
Incidentally, Dr. Deepti, I also handled Kochi bench for about 4 months or so. And my experience in Kochi bench, the bar is very professional. They would like you to deliver justice as fast as possible, and that should be the endeavor of the council anywhere in the and that way what I found is that these people they are very docile. They help you to come to the right decision. And my experience is that the decision making process was very fast in Kochi also. I'll cite you one example. I was handling this Kochi bench from Mumbai only through video conferencing during this COVID period. There was one case, one IA was pending from ex-employees of a company which was into CRP. They wanted themselves to be treated as workmen, whereas all of them were consultant doctors. And this IA was pending for about 1.5 years or so, and they were contesting heavily that they should be considered as workmen. When this IA came before me, and the council who was vehemently arguing that no, Milord, they should be considered as workmen and they should be provided the upper ladder in the process, the preferential payments to them and all that. You see, our experience is that whenever you go to any corporate hospital, there are regular employees as well as there are consultants. And those consultants do their own practice also somewhere outside.
Yes.
This is our experience.
Yes.
It was a corporate hospital because it was into insolvency. I asked them, how do you say that you are employee? They said, Milord, we are getting remuneration from the company, and our appointment letter say that we are employee and we are consultant, we are senior consultants, or designated like that. I said, okay, you show me your income tax return in which the remuneration received from this corporate hospital is taken as salary by you. It is not taken as consultancy. Whether your TDS is deducted under section 192 or 194J. They never came back. And the next hearing, we resolved the issue. So this is how it is. Sister, in your practice years of about 30 years or so, you remained in practice during those times when pre-IBC period was there. IBC came into existence in 2016. And in IBC, you have been through and through in handling the IBC cases while sitting on the bench. Tell me, what is the basic difference you found pre-IBC era and post-IBC?
Pre-IBC, the concept of insolvency was very much embedded in the ground. Because even in practicing lawyers, you will not find that people are insolvency experts or lawyers are taking up only insolvency matters. So the company judge sitting in the High Court used to handle the insolvency matters. The importance given to insolvency matter was not as much as it is given in the code. There were two laws like precedency, as you know, that precedency insolvency law and provision insolvency law, under which a similar kind of arrangement was there that the debtor or the creditor both can file the petition for insolvency. But the understanding even among the lawyers was that once you file under insolvency, it is a dead end and nothing can be probably retrieved. The company definitely will not come out. it is the creditors probably may not get anything. This was the idea in the practice and among the people. When the code came into picture in 2016, the entire idea about the insolvency changed. The prior feel of insolvent, getting declared as insolvent, was considered as very negative,
A stigma on
a
somebody.
stigma, and many of the times they never used to reveal to the people or the other persons. Whereas after the code, the whole idea of insolvency has been put in a positive manner, that once you go in insolvency does not mean that it's a dead end. Number two, it does not mean that there is always some fraud or there is some black area because of which the person has landed in insolvency. But due to these circumstances, if a person is unable to pay, number of resolutions have been given in the code whereby a person in personal insolvency, companies in corporate insolvency, even the code prescribes for the partnership firms and proprietary firm also, which is required to be now notified. So all the business entities can have the solution of their inability to pay the debt by coming under the code. So that is a major shift or the change from the pre-code area and the post-code coming into the picture.
Dr. Deepti, the thing is, if we talk about pre-IBC area, period and post-IBC period, and the advent of NCLT, NCLT has been casted with the responsibility of those three institutions which were handling the cases before pre-IBC. Like the high courts were handling winding up, merger acquisition, or so on. BIFR and AIFR was handling insolvency of the companies. And there was company law board which used to handle the company cases. All of them now consolidated with NCLT. And that is the major change which I have been perceiving or looking at, like that. This is the major change which I have found. Number two, the insolvency part is concerned. Pre-IBC, there were debtors in control. Debtors were having charge of the assets of the company. Post-IBC, the entire shift is now on creditors. Creditors take the entire decision, appointment of RP, constitution of COC, and all that. So now the creditors are in control, then debtors. This is the major thing which I have.
Yes.
Dr. Deepti, you see, you took over in 2018, and the IBC came into force in 2016. Did you find initial hiccups while discharging your function as a member judicial in NCLT?
Of course, when the new law comes up in picture, and especially when the new code coming into force with the new judicial body to implement it, so the experience in a particular new law was always developing. Though the company law was always there, and in High Court the practice of company law definitely helped us in dealing with the company matters, but the code was totally a new law which had to be understood, interpreted, and in the right perspective, and should be made useful for the stakeholders in every manner. So initially, of course, from 2016 up to 2018, the first members appointed had the major burden on their shoulders of deciding certain aspects which were gray area, which were not very clear. But this evolving is still on, and in last 5 years, I would say, as we have seen that there are many amendments in the law. So I think that the process of evolvement and making it better for the stakeholders is still on. But many of the issues which were initially which we faced, like admission, whether the admission should be done if certain provisions are not very clear, Such things had to be looked into and then decided after taking help of the other laws. So initially there was, yes, hiccups, but then slowly you come out with your own interpretation.
Dr. Deepti, you have handled so many benches
Hmm.
during your period. You must have passed so many orders also. You know, our research team has taken out a few cases which are very interesting cases, and we would certainly like to hear from your own mouth that what was going on in your mind while deciding those cases. One such case which our research team has taken out is SBI versus Shri Lal Mahal Limited. It was a Section 7 application, and it was a well contested matter from both the sides. The financial creditor wanted it to be admitted, whereas the corporate debtor took some pleas. Can you elaborate about this case slightly?
Yes. This was in, I think, 2019 beginning. The SBI, being the financial creditor, had filed Section 7 application and asked for the admission, saying that the company is unable to pay the debts. The company on the other side defended, saying that the intention of the corporate debtor is not to escape from the paying debt, but because of the circumstances, the debt could not be paid or debt could not be serviced in time. Now, the major emphasis was placed by the corporate debtor in saying that if there is no intention to defraud or not to pay, then the Section 7 should be considered by considering the other circumstances, and there is no hard and fast rule that Section 7 has to be admitted if there is a default. On the principles of natural justice, the corporate debtor needs to be heard. At length, we heard the arguments. The counsels are represented that the unique case of in this matter was that the date of default was the date just very near to the date when the ED had attached all the accounts of the corporate debtor, and because of which the debt could not be serviced. They had also shown the record that prior to the attachment of ED, all the debt was paid, regularly paid, and there was no default, there was no complaint from the financial creditor. So it was very difficult to understand that there is a pain with the corporate debtor saying that I was restrained or I was unable because of the some other extraneous factors and other departments, some action being taken rightly or wrongly, whatever it may be. So at this stage, Section 7 should not be admitted and we should be given chance. Considering the principles of natural justice, we allowed some time also, that if you can bring some financer or you can make some arrangement of paying debts and convince the bank that they will be doing in a very short period or restructure the debt. But by the time the debt had become vast and the financial creditor SBI was not very much in favor of restructuring or giving any further time, and ultimately considering that we cannot go beyond the provisions of code, which clearly says that if there is a debt and if there is a default, the bench or the adjudicating authority need not go beyond that. And it was not contested that there is no default. That was another hurdle. So ultimately we had to admit that and send it in CIFP.
Yes. In fact, in this case, what had happened that ED attached the bank accounts of the company as well as the promoters, and they were making a they were pleading before you that we don't have any source by which we can make the payment, and that is rather. But the Honorable Supreme Court has made it very clear to Honorable NCLT and NCLT that if there is a debt and there is a default and the amount of the default is more than the threshold limit, you don't have any other option but to accept the case for insolvency.
Yes.
Sister, in one of the case where RP of Mandhana Industries filed a case against In-Style Exports Private Limited under Section 9. I think a landmark judgment was pronounced by you, which finally which finally paved the way for amendment in the act.
Yes. This was a very unique case. At that time, probably I was sitting singly in the Delhi bench, and RP of one of the company which was already undergoing CIRP had filed application under Section 9, saying that the RP has to protect the properties and the debt and recover the debt from its own debtors, so that it can survive or it can revive its own company. Hence, the RP had filed application under Section 9 for recovery, not for recovery, but to receive the debt. Now, the corporate debtor in this application took the shelter under Section 11, saying that under Section 11, no such entity can file because the RP is neither an operational creditor in the definition of operational creditor so far, and in that capacity of RP, he does not have a specific power to initiate legal proceedings against any other entity. Unlike that of a liquidator, which is a very specific provision that liquidator can initiate the legal proceedings against third party after taking permission from the tribunal. So it was, but debt was admitted. It is not that the debt was not there, default was not there. So Section 9 only on the basis, technical basis, that whether the RP has a power or not, that was to be decided. But since the provisions, and as a member of the tribunal, we have to strictly abide by the code and the provisions of code. We can't go beyond. Hence, it was found that, of course, the applicant's arguments were very palatable, that even if there is no provision, there is no
Bar.
intention of the,
There is no bar also.
yeah, there is no bar, and the intention of the legislative members enactment was not that they will debar one particular controller RP and they will allow the other, like liquidator. It cannot be. It may be just a slip that specific provision is not made. But ultimately, the Section 11 and read with the no power, specific powers of RP, though I had rejected the application, but I had sent this order to IBBI saying that this particular lacuna has to be filled in, and a proper explanation, or if required, maybe amendment is required to make it clear, because most of the companies first will be handled by IRP and RP. So if they have the power, probably by recovering some amount, probably we can avoid liquidation also. And I think December 2019, the amendment came in, when they have introduced that even corporate debtor which is undergoing CIRP can file application under Section 9.
Dr. Deepti, there was one another case which you handled in Delhi, that was Concord versus Shubkamna. And I believe there was an IA which was filed by Greater Noida Industrial Development Authority.
Yes.
For favorable order for them to consider them as financial creditor rather than operational creditor, to consider them as a secured creditor than unsecured creditor, and finally let them allowed to sit in COC.
Yes, this was again a highly contested matter. The Section 9 application was admitted against Shubkamna. It was a
real estate
company, and they had many projects at that time. The stake of probably thousands of the residential unit holders was involved, and there were internal transactions of the lands, development rights being given to others. So the matter was quite complicated. During the CIRP, Greater Noida Authority had filed an application. Of course, they had filed a claim before the RP for the license premium not paid by the corporate debtor for quite a huge amount, and they had claimed that they become financial creditor because only after they are allowing to the corporate debtor the land on the leasehold basis, they could go ahead with the project. So it is basically a finance, another way to the corporate debtor and they should be considered as a financial. When the matter was argued, they argued on the point that the lease agreement is, or it should be declared as a financial lease as per the accounting standards, because it has all the terms of financial lease agreement. The corporate debtor, on the other hand, argued that it is not a financial lease, and secondly, there was no finance given by the authority, hence they cannot be financial. After going through the provisions, accounting standards for the lease, financial lease and normal lease, it was found that the strict definition of financial lease was not complied in this lease agreement, and I had opined that according to me this is not a financial lease, and hence if this is not a financial lease, they cannot be financial creditor. They'll be secure creditors but not financial creditors, and they cannot sit in the COC. Of course, this was challenged before the NCLT. NCLT upheld that this is not a financial lease. They went into Supreme Court. Supreme Court also held that this cannot be declared as a financial lease, so they cannot become a financial creditor. They'll be secure creditors like any other government authority, but they cannot sit on COC.
Sister, I'll cite a very live example to you. You see, I remained CFO of Haryana State Industrial Development Corporation, which is akin to GNIDA,
Yes.
Greater Noida
Yes.
Industrial Development Authority in Haryana.
Yes.
But the basic difference between Haryana and UP is Greater Noida Industrial Development Authority, Noida Industrial Development Authority, Noida, or all the industrial, in majority of the states, the land is allotted by this development agency to the allottees on leasehold basis.
Yes.
Whereas in Haryana, we are on a different footing. In Haryana, we allot land from Haryana State Industrial Development Corporation to the allottees on freehold basis. There is a basic difference.
Okay.
So, you see, your decision has been upheld by Honorable Supreme Court also, constituting it as an operational lease rather than a financial lease.
Yes. Yes.
That was the crux of this case.
Correct. Correct. Even the other Maharashtra also, MIDC, what we say is
MIDC.
Industrial Corporation.
That also
They also give in the leasehold. Round.
Almost all the states except Haryana or few more.
Few more. Yes. So the ownership does not get transferred. You are only there till the wish and will of that particular authority.
Yes. And further transferring of the rights to the allottee by the lessee are only leasehold rights.
Right. That will be sublease.
That's a sublease.
That's a sublease. Right.
Yes. Dr. Deepti, in one of the case, RP of Nisa Leisure Limited versus RICO, you passed some judgment in Ahmedabad.
Yes.
And it was again on a leasehold property given by the State Industrial Development Corporation, RICO, to the allottee and the corporate debtor in your case. What was that case and what was your decision?
The Nisha Leisure Limited was under CIRP, and the RP of that company was in process of taking up the properties or taking control of the properties. Now, RICO had given on lease basis plot to the corporate debtor Nisha Leisure, and before the CIRP initiated, because of non-payment of the lease premium, the RICO had already cancelled the lease. After that, the company went into appeal against that cancellation. The appeal was dismissed. They went in second appeal. Second appeal also was dismissed. But during all this process, the company went into CIRP, and the process of taking the physical possession by RICO from the corporate debtor was in process. Yes, was in process. So, knowing that the company is in CIRP, RICO initiated the process of taking physical possession and sent a show cause notice. That show cause notice was challenged by the RP, saying that now there is a moratorium and no authority or anybody can take any possession of any of the properties of the corporate debtor, and everything should be under the control in the CIRP with the RP. On examining and after hearing the RECO, it was found that the lease was cancelled by the RECO much prior to the initiation of CIRP. Though the appeal was dismissed, the one of the defense taken was that the writ petition is still pending and the final outcome is still pending. So in that case, it should be considered and the benefit should be given to the RP, and the land should not, the copper debtor should not be dispossessed, or the possession should not be given to the RECO back.
So you allowed them continuing the possession of the land and enjoying the property.
No, because the RECO did not start any process of taking physical possession.
Yes.
That issue of allowing them or not did not come. It's only when the RECO came, when the RP came in saying that the RECO has initiated the process and that should be stopped because of the moratorium. The issue came before us. Then we went back and we saw that the process is much prior. So if the lease is cancelled, the appeal is dismissed, the cancellation stands valid on the day. So once the cancellation is valid, that means the corporate debtor had no locus standi
Yes.
and objecting to the taking possession. Hence, we dismissed the application of the RP and allowed the RECO to take whatever legal process they have to go ahead with.
In one of the case, City Securities versus RP and COC of Reliance Naval.
Naval, yes. Not convertible venture. This was a case where the sister concern or any other coordinate corporate entity had given a loan to Reliance Naval, the corporate debtor, which was under CIRP. And they had, after the CIRP initiated, they had filed a claim saying that we are the financial creditors because we have advanced the loans. Now, RP rejected that, saying that under section 21(2), you cannot be entertained and you are disqualified to be a financial creditor and sit in COC. During that process, when the application was heard and the claim was being filed and all, the entity which had given the loan assigned its debt to the City Securities, entire debt, and after they were disqualified by the RP as a financial creditor, the City Securities, after getting the assignment, they filed separate applications saying that now, since we have come in the shoes of the company, but we are totally different entity, so we cannot be disqualified under 21 by saying that the disqualification of the prior entity still continues.
But sister, the way I look at it, any financial creditor, irrespective whether it is related party or not,
yes,
his claim cannot be denied. Only thing is whether he will be sitting in COC or not, that only that is to be making a change.
Yes, yes.
Otherwise, claimant is claimant, whether he is a related party or not related party.
Correct.
Is it
correct?
Is it the position?
Yes, yes, yes. So we rejected the contention of the City Securities, saying that you cannot become a financial creditor being in the COC along with the other creditors.
Yes.
You will be creditor. You will be other creditor, but not the financial creditor sitting in COC. And that was, I think, upheld by the NCLT.
Basically, if you are a related party by assigning that debt,
yes,
you cannot become unrelated party.
Right.
You will remain as a related party.
You cannot find a way out when you directly can't have something.
Yes.
You go round the bush and then come and ask for something which is not available to you.
In one another case, Power Finance Corporation versus Maheshwar Hydel project.
Yes.
You decided something with respect to convertible debenture, whether actually done or not.
Yes.
Please elaborate on that.
No, that the issue before us was the admissibility of Section 7. The contention taken by the corporate debtor was that during the process of the financing and repayment, the finance corporation had one clause with them saying that in case if there is a particular payment is not coming forward, then the Power Finance Corporation has the powers of converting certain amount of loan or the finance into debentures, and then they can enter in the company by being a debenture holders, so that they can have more clarity and transparency control in the company. In that, the because of the non payment of certain debt, the power finance had exercised its rights of converting the into debentures, and they had taken control, because they become majority and they had taken control of the company. So the corporate debtor argued that because they had taken control of the company, and when they had a control, the default has occurred, which should not be attributed to the default by the corporate debtor, and the benefit should be given. Of course, this was a government undertaking. This was a hydel power project. The Madhya Pradesh government also had a stake. There was involvement at a very higher level. A lot of discussions, and it was allowed, and it was stated that the project has to go on, because if we put it in CIRP, probably the project will not take up its shape, which was long pending. So it was very difficult that whether to admit it as per the provision which is required to be, because there is a debt and default, and which is not denied, but only by saying that there is a debt and default if the entire project is coming to a halt, which will affect number of people, because the benefit of this hydel project was to be given to certain villages. Now if all that will stop, probably there will be major issue coming up next. But ultimately, in the code and in the limitation of the provisions of the code,
You had to admit it.
I had to admit it, though there was a difference of opinion.
Yes.
But ultimately the admission was confirmed, and we had said that the company can always come up with the ideas
Yes.
of getting the finance, and even the power finance corporation had shown the willingness that even they want the project to go on, but there was no other alternative.
That way, sister, as the adjudicating authority, we have certain limitations
Yes.
within which we have to work.
Work.
And you see, we have to look at the superior courts also,
Yes.
NCLT and Supreme Court,
Yes.
and their decisions. They are very clear in this issue
Yes.
that once there is a debt, once there is a default, and default is beyond the threshold limit,
Right.
you have no other alternative except to accept the case into insolvency.
Yes.
So,
Probably what I would like to say is that the Supreme Court and the Appellate Court has felt this need of defining or putting it in a very narrow span, because that if you allow such kind of defense, or if you allow such kind of,
then there will be a
issues of-
plethora of
Yes.
defenses available
Yes.
with everybody.
then it will be a litigating part,
Yes.
and we do not want litigation, we want resolution. So if you want to resolve it, you have to streamline or make it a watertight compartment,
Yes.
that this has to go for resolution.
Sister, you see, with your experience on the benches and now after, demitting the office, uh, what is your first-hand experience with respect to IBC, its origin in 2016, implementation till now, where we are standing today, what have we achieved, where we are standing today, and what is your outlook about its prospects, and what type of tweaking do you think that should be done so that better results for IBC can be achieved?
Initially, I would say that 2016 onwards, it's a game changer law in financial stability of the nation. At that particular time, the debt recovery was very low. The creditors or the business people all were in doldrums, and nothing was coming out in the system to as to where to start and how to start.
Yes.
The moment code came into picture, as you rightly said, that this is a creditor's law, and creditors have come in control. The debtors, those who were not intending to pay or those who were delaying it to pay, got the lesson that the debt has to be paid in time. They can't play with the financial institutions, and there is a deterrent law which is going to act very fast and bring the results. So the psychology, or rather I would say the mentality of the debtors, had a remarkable change. That is number one. Secondly, what I would say is that till the code showed its results and started coming into existence and affecting the stakeholders, probably all over it was a very dull situation, because the recoveries and the resolutions were very far off for the creators as well as for the companies and debtors also. But with this code, probably it has given a speed, and the probably I would say that the common, very general business person also knows about the insolvency, its effect, the law, and the consequences. So that has changed quite a bit, and there is a lot of movement in financial field. So according to me, this has really striken at the right time, the right nail, so that the imbalance or any kind of I would say that derogation in our financial status could be stopped. Of course, it's a evolving law and lot of things being changed. The amendments, as you rightly said, that it's pending in Parliament, which will be very probably soon considered. Two or three points while sitting in the bench and while practicing, which has struck to my mind, and which is um, I have been giving a lot of thought to it. That, as you rightly said, that there is something which is still needs improvisation. So I will say that one or two points which comes to my mind is that MSMEs, though we have given the pre-pack insolvency provisions to them, but MSMEs, I would say that they are the basic structure, backbone and basic structure of all the multinational companies or big corporates, because they are based ultimately and dependent on these MSMEs. Now, somewhere down the line, there has to be some amendment to be brought whereby MSMEs can be not only revived, but they should be protected in some way or the other, so that the smaller stakeholders, because all MSMEs are small stakeholders, and their survival is wholly dependent on the debt and recovery. So there is some thought to be given to saving the MSMEs. Secondly, what I thought that the in the resolution plan, or maybe in the liquidation, when the distribution comes, according to me, the operational creditors are the sufferers at the end of the day. Even if they file the petition or application and they get the order of admission, ultimately while recovering or getting something, they are always dry handed. So that is another issue. And I would say that operational creditors are again the lifeline of the business. Such small units, when they get hit, it definitely affects the bigger industries. So while distribution, I was even prior and in now of the opinion that they should be put
So some weightage should be
somewhere.
given to them,
Yes,
not like
some
1 rupee given to them or 10
exactly,
given.
exactly.
Yes.
I recollect that most of the plans, nothing is given to the operational creditors.
Yes.
Very maybe you can count on fingers that plans they'll say that okay, we'll give to the operational creditors
Because they don't have any right, that's why they are not being considered by the
exactly, and they stand like a beggar in the line.
Yes,
And don't get anything. So that status, if it is removed, the operational creditors, all the small units will get a good boost, which probably will bring more people coming in the business. Right now, the small operators or the small creditors, they are totally disappointed.
Sister, as far as this MSME is concerned, you see, absolutely right that the operational creditor can be MSME. But if you look at it, the corporate debtor can also be MSME.
Yes,
In most of the time, MSME, corporate debtor is also MSME.
correct.
So we need to balance for both of them.
Yes.
When I was sitting in the benches, and so many times I have heard this argument from the operational creditor who is coming, is my lord, they are not paying us, that's fine. We are hit by COVID.
Correct.
I always used to say, you're absolutely fine. Your dues are there,
Yes.
which must be paid by the corporate debtor.
Yes.
But if you are charging interest on the basis of a clause written in the 18%
MSME
interest
Act.
will be charged, you see, this is somehow, because he is also an MSME. He is also hit by COVID.
Yes.
It's not only that you are hit by credit. He is also hit by credit.
Correct.
So normally what I used to do, there is now a lot of buzzword which is coming in, mediation.
Mediation, yes.
We earlier used to do mediation sitting in the benches also.
Yes.
You see, as far as principal is concerned, this amount is due, payable to you, take it.
Yes.
But don't insist too much on interest
part. Yes.
Because if he was not able to pay, that is why he is coming here as a corporate debtor. So
yes.
You won't believe, sister, thousands of cases I have got settled by persuasion on this interest front.
Yes.
And the corporate debtor, if he has capacity to pay, it's a running unit.
Correct.
He doesn't mind paying the amount.
Yes.
But interest pinches to him also.
Yes. Yes.
So many cases I have got settled like this. I was reading somewhere in the latest data released by IBBI that more than 25,000 cases have been settled pre-admission stage.
Yes.
And more than 8 lakh crore rupees has been recovered because of that.
Yes.
So this is the real crux of this IBC.
IBC, correct.
And the credit totally goes to IBC.
Yes.
Otherwise, creditor was high and dry.
Yes.
He was running high and dry.
Yes. And the speedy nature of the act taken and the speedy disposal has brought both the parties at one table to decide. Because in previous regime, civil suits or winding up petitions getting pending for 2, 3, 5, 8 years. So the debtor used to feel relaxed. When it will come, we will see. But now he's very alert, knowing that anytime it will come and anytime he has to make a commitment.
Since this case is already over, I can very well cite one example to you, which will clearly give you an idea about operational creditor, MSME and all that. One major unit, Kinetic, I can name it because it's over now. Kinetic was into some problem and the operational creditor filed Section 9 petition for 1.17 crore rupees of dues. And plus interest was about 23 lakhs, totaling to 1.40 crore. When we heard the entire case, we understood that the claim of the operational creditor is quite genuine and the company is likely to be admitted as into insolvency. There are more than, I believe, 500 employees working in Kinetic. We asked them, you see, we are satisfied that the case is going to be admitted.
Yes.
We are giving you 7 days time. Either you settle with them or get the order of insolvency from us. They said, give us 7 days time. After 7 days, they came with a demand draft in hand of rupees 1.17 crore. And they said that we are ready to settle. The operational creditor was too adamant on interest part. 23 lakh rupees interest I need, otherwise I will not be admitting. He wanted to basically, arm twisting he wanted to do with them. We understood it. On the bench, we understood that the party is ready to pay, the corporate debtor is ready to pay, but he is now adamant. He said, no, my lord, for 2 years they have not paid, we will charge interest or something. He said, as operational creditor, what are you going to get even if we put into insolvency? So we asked the advocate, the party was, both the partners of the operational creditor were present in person.
Okay.
And they said, my lord, we will not be agreeing. We asked the counsel, They said we can dismiss this case also.
Yes.
Reason being, in your books of accounts, you have never provided for interest.
Yes.
So somehow,
Huh.
in 10 minutes time,
Uh-huh.
we were able to solve that
Solve the
matter,
issue.
solve the
Yes.
matter.
Yes.
Otherwise, he was sticking on interest, and this is how the operational criteria is sometimes is to be.
Yes. This is the understanding the bench members. The moment they have it, they show that if you're not going to agree to it, probably you will face the music of it, and then they understand through
So
counsels.
sometimes the active participation by the member
Yes.
makes a difference.
Absolutely.
Makes a difference.
Absolutely.
And you have to understand the business, that what it is.
It is correct.
Yes.
Correct.
So, sister, as far as the, matlab, you see, we have discussed with the things of what we are doing today and where we should. Do you have one or two pointers for the others to basically imbibe in them, so that faster decision could be made in NCLT or NCLT?
In NCLT, of course, one of the point which was taken for faster disposal was that there is a lot of delay and applications should be stopped. One of the suggestion or recommendation had come in our colloquium that there should be bar in filing of many applications, or at some stage there should be some limit. Now that, in my opinion, you cannot do it, because if the person has a statutory right of coming to the court, rightly or wrongly, whatever, at the most we can dismiss it in limine, or maybe prima facie not finding any case, put the cause, which we all benches do.
Yes.
So in that case, but pointer wise, number one, the entire attitude or the mentality of doing business with transparency and in good faith with against each other has to be cultivated. Infrastructure and the business culture does not imbibe the paymaster role or transparency or having more honest transactions, these kind of things we cannot control.
Sister, in one of the recent judgments, Honorable Supreme Court has passed an order that RP, as an officer of the court, should not be indulging himself into the unnecessary litigation
Yes.
and filing IAs
Yes.
in the process.
Yes.
You see, I have seen that judgment of Honorable Supreme Court. Honorable Supreme Court has never passed a general order that RP should not be filing IAs.
Right.
There are apprehensions in the minds of RPs, and that RP is now restricted by the Honorable Supreme Court in filing applications. It's not that. The first sentence of the judgment starts with the, in view of the facts of this case.
Yes.
We find that there was no necessity for RP to file an
this.
IA or an appeal in this case. You see, what is your outlook? Can RP be barred from filing appeals?
We cannot have a straight jacket bar on filing any legal proceedings by anybody.
Exactly. This is
Because
what my
it's
point
a
is.
fundamental right to seek justice. Now, what is injustice to me may not be injustice to you.
Absolutely.
But I have full right to decide whether I can go to the court or not.
More so, RP is necessarily a party.
Yes.
In almost all the litigation by any of the parties.
Correct.
Because he is representing the corporate debtor, and wherever the corporate debtor is to be made party, it is in the name of RP.
Yes.
Now, if RP is not satisfied with the judgment of NCLT or Honorable NCLT, he has every right to go to the appellate court.
Yes.
So no blanket bar can be put on RP.
Yes.
However, it has been basically publicized as if the RP have been barred from filing appeals.
Yes.
Which is not the case. I think both of us agree on this.
Yes, absolutely. What happens is that the interpretation of understanding of law has to be more in depth, and secondly, the RPs or liquidators will have to get more of legal opinion before going for the litigation. That's only a precautionary measure they can take. But of course, they have a right to go. Maybe if they don't file appeal, probably somebody might point out that he is not interested in taking up the issue. So that should not happen.
You just said, sister,
Yes.
about the operational creditors' rights,
Right.
and some injustice is done in almost all the resolution plans with the operational creditors. What is your take on that? Because you see, as per the law as it stands today, operational creditor is not forming part of COC.
Yes.
If there are secured creditors, the secured creditors will be taking care of. If there are financial creditors will be sitting in the COC. If there is no financial creditor, only then the operational creditor will be coming into picture. Do you think that some tweaking is required with respect to operational creditors representation in COC?
Yes, definitely yes. When I say that the operational creditors needs to be protected somehow or the other, of course, also had, though I had not specifically mentioned, but of course I had in mind that unless they come on board, because whenever the plan is discussed, plan is passed, approved, till the adjudicating authority approves the plan, operational creditors do not have any idea what is going on. Sometimes it happens that some of the financial creditors have lesser claim than some of the operational creditors.
To my mind, sister, a solution to this can come where we can have a proportionate representation system
Yes.
between the financial creditor and operational creditor.
Absolutely, absolutely. That will be the right.
If there are 98% financial creditor, 2% operational creditor, let the case may be as
Yes,
it is.
Yes.
And let 2% not prevail on 98%.
Correct.
But if
Yes.
it is other way around, there are 80% operational creditor and 20% financial creditor, then let these poor operational creditors have some say in COC.
Yes, absolutely, absolutely. That's what I say. Sometimes the financial creditors have lesser amount than one of the major operational creditor, and he's totally debarred from deciding anything.
The government can consider for proportional representation system with the financial creditor and operational creditor putting together.
Yes, yes. So representation on COC and reconsideration of their distribution under 53.
Not in the basically case I was dealing with, one of the case which was not of IBC, it was for merger and acquisition. It was one of the largest groups in India, and what I found is their paid up capital plus reserve are 5,000 crore. Their secured creditors are 20,000 crore.
Correct.
And their operational creditors are 55,000 crore.
That's
now see who is financing this company. Exactly. These are the operational creditors who are financing this company.
Absolutely. In one of the talk, I had said that if the operational creditors consider that all the operational creditors will withdraw and will not supply or will not take orders or purchase or sale, what will happen to the company? Company will not run, and if the company will not run, what about financial creditors? They will not get their servicing of the debts. So servicing of debts to a certain extent also depends on the operational creditors, definitely.
I remember they had a very senior lawyers arguing the case, and they said, "My lord, the notice to operational creditor is not necessary." I said, "Who is financing your company? Just see."
Yes, we have to take that role of telling that each case is a different case.
So then we had to pass the order of notice to the operational creditors.
Yes.
But keeping in view of the large number of operational creditors, we restricted the threshold amount, and more than 50 lakh rupees we issued the notice. That took care of 95% of the operational creditors.
Correct. And when body of operational creditor represents them, definitely the others also will be protected.
But they have every say to say something.
Come in the process.
They have every right to say.
Come in the process.
Because your company is financed by the operational creditor, not by the equity. Okay, with this, Dr. Deepti, we come to end of this talk show, and we would be looking forward for further interactions with you in future. Thank you very much.
Thank you.